Okay, thank you all for being here. We're doing training for our hearing officers today for the 2022 election cycle. To start out, we're going to ask Barb Goodman. All of you know Barb, probably the preeminent hearing officer in the state of Illinois. She does it for us, for the city, for the state, for everybody. Everybody wants Barb. We've got her. So she's going to run through just kind of an outline of procedures. Many of you have done this before, and I understand you might be familiar, but it's a good refresher. With COVID, it's been a couple of years since we all were able to get together and do anything. So I'm going to let Barb make a presentation. Any questions you have for Barb, you can ask. Then I'm going to give you some general information about our timeline and some of the things we're going to do in terms of procedures, and we'll try to get everybody out of here at a reasonable time. All right, so with that, Barb Goodman.
So, just looking around as to who's here, I realize that this is probably a little bit more elementary and fundamental, than you necessarily need, because most of you know all of this, but hopefully it'll serve as some refresher. So we're going to talk about, the hearing process. We have a flow chart and some general information about electoral boards, just to remind everybody where the authority derives with electoral boards. We'll talk about, what our role is, what the objector's petition looks like, the components of the nominating papers, and the challenges that we all have encountered or will encounter preparing for and conducting the hearing, the hearing officer's report and recommendation, and some important terms that most of you are familiar with, but just it's always good to refresh. So here's our little flow chart, and as you know, what happens once the objections are filed, they then go to Jim, and Jim takes a look at them and assigns the cases to the various hearing officers. Essentially, the electoral board assigns them to the hearing officers. I want to pause right here to just say that this is the point in time when you find out when you are assigned a case, to let Jim know if there's any conflicts of any kind. If you anticipate a conflict with either the parties or really the attorneys, it would be a good idea to let Jim know at that time, so that before the call goes out, he can maybe make some changes as to what your cases are going to be that you're going to be hearing. So the cases get assigned from the electoral board to the hearing officer, and then once you hold your hearing, you submit a report and a recommendation. The report and recommendation goes to Jim, and Jim will take a look at it. Hopefully he'll agree with what you say. Sometimes he disagrees. But he will then submit a written recommendation to the electoral board based upon your recommendation. And then the electoral board renders the final decision. So it goes, I'm not sure what just happened there. Well, now we're watching the news.
Okay, just click over on the side.
There we go, sorry about that. So it goes from you finish the hearing, you do your recommendation, you send it to Jim, Jim makes a recommendation, the electoral board makes the final decision. So nothing new so far, right? All of you knew that. So just a refresher on the role of the electoral board and who they are and what they do. So the county officers electoral board is comprised of the Cook County clerk, the state's attorney, and the clerk of the circuit court, or their designees. And I think for several years it's always been designees for the board. And as you know, the sole purpose that they have is to hear objections to nominating papers and for referenda. I don't know if we're going to have any of this cycle. There is a mistake here. This is not the cycle where people are running for municipal office. Jim will go through what offices are to be elected. But in any event, the electoral board is responsible for hearing the objections essentially through you to render a decision. Just as a refresher, the electoral board's authority derives from and is set out in the election code at 10-8 through 10.10.1. So if you haven't looked at it for a while in the last several cycles that you've been doing this, it's always a good idea to just take a look, because as you know, the electoral board has specific authority and is governed by specific procedures. And the electoral board comes into existence upon the filing of these objections and then is done when the objections are done. So they don't exist as a board that sits for any other reason other than to hear the objections. So, just a couple of other things about electoral boards, just that you need to know. So electoral boards don't sit in executive session. They're subject to the Open Meetings Act, and there's no executive session for electoral boards. So please don't assume that when you submit a recommendation that the board is going to be considering, that they're going to be considering it in private. They are not. The consideration has to take place in public. They're subject to the Open Meetings Act. At the first meeting, as you know, they'll adopt rules of procedure. So the rules of procedure change at every cycle, somewhat. If there's any major changes, Jim will bring them to our attention. I don't think there's going to be anything major. For those of you who participated in some of the most recent hearings, you know that we worked on that Jim had made some changes to the subpoena rules and a couple of other things, but it's really important that every time we get a new set of rules, that you take a look at them and you become familiar with them. Every once in a while, we even change the numbering. That really messes people up. And then at the first hearing, what the board will do is the board will assign the cases to the hearing officers who have been approved by the board. So I assume that everybody here has been approved or will be approved. And then that becomes your docket that you control. As we said, the electoral board, however, is the one that makes the final decision. It's not you as a hearing officer. You're just making a recommendation. You are conducting hearings on behalf of the board, so you generally have the same authority as the board, with some exceptions that are set forth below. So we already talked about where the electoral board's authority derives from, and in what section of the election code. And the general authority is in 10-10. So, I have a little trouble, sorry about that. We'll fix this. This is not a PowerPoint, it's a PDF, so I'm having a little trouble with this roll. So one of the things that you do not have the authority to do, and this is a really important thing, is that you don't have the authority to modify the rules of procedure. And it's really important that everybody follows the same rules, because the last thing that we want is for somebody to file a motion that the rules have not been applied to you the same way they've been applied to, the rules haven't been applied to the same parties as with another hearing officer, or that the hearing officer is applying them, inconsistently. So please just make sure that you follow the rules, and that's why we want you to become aware of them. The next thing that we want to talk about is the objector's petition. All of you are familiar with them. I apologize, because I know that most of you, if not all of you, have seen them, but for those of you who might be watching this later on and might be a new hearing officer, here's what they look like, and here's what they are. They are a pleading challenging the validity of nominating petitions. They should be nothing else than that. That's what they should be. They should not contain statements regarding political opinions, etc. And to be qualified to be an objector, as you know, the objector has to be a legal voter of the political subdivision or district in which the candidate is to be voted on. The objector is not required to prove standing, but as you know, that can be an affirmative defense. If the objector isn't a registered voter, then it can be brought as an affirmative defense by the candidate or the candidate's counsel. All of the requirement of the contents of an objector's petition is contained in 10-8 of the election code. And again, if you haven't looked at it for a while, just take a brief look. I know you all know it, but it's always a good thing to just review. One of the things that we always talk about is once they're filed, they cannot be amended. So the objector is stuck with whatever they file, and that is the pleading. If they have forgotten something, they can't amend it. They can withdraw paragraphs, but they cannot add anything. And anything can be withdrawn by the objector at any time throughout the hearing. And oftentimes that happens because where an objector sees they're not necessarily successful in what they're doing, they may say, you know what, I'm just going to withdraw that paragraph. And also, some of the paragraphs can be stricken in, a motion to strike as well. The other thing that is just a good thing to mention is it's not the Electoral Board and it's not you as a hearing officer that has the authority to raise objections. So you might see something in the petition that the objector hasn't seen, and oftentimes that's happened, where you see something glaring and it is not for you to raise any of your own objections, and the Electoral Board doesn't raise them as well. So moving on to the components of the nominating papers, you've seen what nominating papers look like. And they consist of the statement of candidacy, the petition sheets, the individual petition sheets, the receipt for the filing of the statement of economic interests, and a loyalty oath sometimes. The loyalty oath is still and always has been for years. It's optional, but everybody in old habits die hard, and everybody still likes to file them. So that's what the nominating papers look like. All nominating papers that are in apparent conformity are considered to be valid, so unless they're challenged. So essentially, unless there's something glaring that makes it very clear that that the nominating papers are not valid, they're deemed valid, and then the Electoral Board is required then to wait to see if there's an objection. Otherwise, the candidate's nominating papers are deemed to be okay and in conformity. So we've all been through this, and at least the people in this room. So let's just talk real briefly about the kinds of challenges that you might encounter with respect to the statement of candidacy. Okay, so the first thing is challenges to the content and the wording used in the statement. We know that any kind of inconsistency within the document or within the several documents of the nominating papers creates a problem, because if the statement of candidacy says I'm running for judge of whatever judicial circuit and the petitions say something different, the inconsistency may be enough to be considered to be a fatal defect, because the board doesn't know and nobody would know what to certify the candidate as. The candidate is asking to be placed on the ballot and is stating their qualifications for one thing, but they've filed petitions for a different district or whatever the case may be. So sometimes you get challenges on the content and the wording used in the statement. There's another aspect to the statement of candidacy. The statement of candidacy declares the candidate's qualifications. So if a candidate declares that they have certain qualifications and they do not, that is also the subject. That also can be the subject of an objection. Jim probably will spend a little bit of time talking about the sheriff's, the issue that's coming up with respect to the sheriff's candidates. We'll talk about that later on. And then, of course, there's challenges to the signing of the statement of candidacy and the notarization. So those are all things that can be raised, and I'm sure all of you in this room have heard objections to those things, and all of you, have consulted the current case law to know how to handle them. And we already talked about the kind of challenge that challenges the consistency within the statement and then the statement in relation to the petition sheets. So then you've got, of course, and this is the one that we're all used to, the challenges regarding the petition sheets. So there are challenges, first of all, to the form that's used and to the heading. And again, the heading has to have certain language, that meets the statutory requirements, and if it does not, it can be a fatal defect in the petition. It's a lawyer's nightmare if a lawyer has prepared the petitions for the candidate. And of course, the big one is the challenges to the number of the valid signatures on the face of the petition and the number of valid signatures contained in the nominating paper. So first of all, there is a challenge that somebody can bring that simply says, we've counted the numbers and we just, on its face, the nominating papers just don't have enough signatures. That being the case, that's about as simple as you can get. We like those kinds of objections because there's really no room for error. You count the signatures, and even if there's blanks, and even if you were to give the candidate the benefit of the doubt for certain lines or whatever, if the signatures aren't there, they're just not there. There's also the question of the number of valid signatures as set forth on the appendix recapitulation sheets. So for those of you who don't know, I know probably everybody in this room knows, but an appendix recapitulation sheet is something that gets attached to the body of the objector's petition that sets out with specificity the sheet and the line and the nature of the objection for each of those sheets and lines. And usually they're designated by some X. It's usually a graph. It's a sheet that looks like a graph for all of you who you know are not familiar with it. And that's where the specificity regarding the signatures are contained. There can be objections to improper page numbering. There's some pretty draconian remedies regarding the failure to properly number the pages. There's a whole body of case law. Who would have ever thought that would be body of law, but okay. There's challenges to the binding of petitions, and that, again, there's a whole body of law regarding, you know, if you ever want to read about paper clips and binder clips and whatever, go to the cases regarding the proper binding of petition sheets. But it's important that you know, and you're familiar with these things, because it's very possible that you could catch a challenge, you know, you could be hearing a challenge to those kinds of things. There's a body of law, and it's a big one, regarding the challenges to the notarization process. We as attorneys know that there's areas of law where the notary process is really important. It should be important everywhere, and it should be important to all notaries and everybody who's acting as a notary, but it's really taken seriously in the area of election law. So that is an area that has, if the sheets are not properly notarized, were not properly witnessed, that is a large body of law, and you might catch a challenge on that. And then, of course, the last one is the whole circulators process. You know, there's things that need to happen in the circulation process. The circulator has to see the signers sign, and they have to fill out an affidavit saying that they swear that they saw the signers sign. Of course, there's bodies of law as to where people can be standing and how far they can be, and whether they really could see them, or whatever the case may be. But that is, again, an area that I'm sure all of you have had where you've had to deal with, you know, the circulation process and the circulator's affidavit. Then you have the challenges to I'm sure there's a better way to do this, to the statement of economic interest. So as you know, as we talked about, every nominating paper, every set of petitions has to come with it a receipt for the filing of the statement of economic interests. And that particular form and that particular issue gives rise to other problems. So one of them, of course, is a challenge that the receipt is just not attached. That's a relatively easy one, because it's there, or it wasn't, it was filed, or it wasn't, and so on and so forth. There's challenges to the office for which the receipt was filed. So the question is, if somebody is seeking an office and they have filed a receipt for the statement of economic interest for a different office, what does that mean? There's a legal consequence to that. There's a challenge to the timing of the filing as well, of the receipt. And then there's challenges to the designation of the office on the statement of economic interest. So I'm sure all of you have had those issues as well that you've had to address. For whatever reason, I find those particular issues to be challenging, because there's lots of different twists and turns for those, and the filing dates and so on and so forth. Okay. Challenges to the loyalty oath. We already talked about the fact that a loyalty oath is not required, and there's generally no valid objections to them. However, I have been involved in cases where the signature on the loyalty oath was considered in determining whether this candidate's signature was valid and whether the notary's signature was valid, whether the notary actually notarized and what the process was involved with that form. So it could be some evidence. It's just that if you have an invalid loyalty oath on its own, that's not a sufficient objection. We good so far? Okay. Okay, so preparing for the hearings. Prior to the first day of the hearings, there's just no way to emphasize this enough. I already mentioned it once. Please look at the rules of procedure. If you're working with different boards, I know some of you are, at least one of you is probably working for the state, the county, and the city. The rules are not only different, but the numbering is different. So a Rule 8 in this board might be a Rule 9 with the state, and so on and so forth. So it's really important that you get familiar with each of the board's specific rules of procedure and the dates and the deadlines that they're going to be using. You know, not all boards apply the one business day for a motion and another business day for a response, and so on and so forth. So it's really just, it's important that you look at those rules. Can't emphasize it enough. And then before the hearing, you want to review the objector's petition and the nominating papers, and then, you know, kind of make some notes if you can about the issues that are presented, so that you have some familiarity. So, you know, especially with the first hearing, you know, you're sort of up to speed on what you're dealing with, and whether or not a records examination is going to be required, and whether or not it's just going to be legal issues that are presented, so you can really move the hearing along better if you're prepared on that very first day. There are lots of great resources for election cases, thanks to all of the attorneys that have been involved, the general counsels for the boards that have been involved with putting together these great resources. So you're going to want to look at, you know, the index of electoral board decisions and an electoral board handbook, or whatever is going to be made available, and you know maybe get your case law, kind of figure out where things are at, so that you can conduct the hearing intelligently. That's sort of our goal.
And we will have, Barb, we will have a hearing officer's library that we've had in the past that you'll be able to consult, and a lot of the written resources will be available in that library. And we'll be sending you a link to that, so you'll have that on your computers.
Okay. So on the first day of hearings, and I know, I don't know, Jim, if you want to talk a little bit about how the first day is going to go, or we want to come back to it, but you know, generally speaking, in a non-COVID year, on the first day of hearings, we would you know, hold the case management hearings, and so all you have to do is call the names of the parties and the case number, introduce yourself as the hearing officer, make sure the parties are on record introducing themselves, make sure that whoever is speaking submits an appearance, submits a non-disclosure form, and confirms their contact information. By now, everybody is pretty much using email, but at some point in time, there was a choice of, you know, people saying, you know, well, either we want everything faxed, or we want, you know, instead of email. And I think everybody's using email now, but in any event, it's really important that all that contact information be provided, and it's most important that you provide your contact information to the parties, because you're going to want to be copied, and they're going to need to copy you on everything that they file with the board. So that's what you want to introduce, and the rules that you're going to get will, I think, the county's rules set out what you want entered into as exhibits.
Yes.
Okay. So on the first day, you're going to confirm that everybody has received the call and the rules of procedure. And all of this is just in an effort to make sure that nobody has an objection to, but when they're standing there, to something that they haven't received, something that they haven't been notified of, and so on and so forth. Make sure that the candidate has received the copy of the objector's petition. I presume that they will have, because they're standing there at the hearing, so there's only one way that they got to the hearing, is they were notified of an objection and they got a copy. We've already talked about the fact that you're going to want to provide the manner of service and the email addresses of all the parties, and this is what I have for the board exhibits that we have to enter into the record. And I don't know if the letters are going to stay the same, but this is what we had from prior years. So you're going to enter the nominating papers and its various components. So the statement of candidacy, the loyalty oath, everything that constitutes the nominating papers as Board Exhibit A. As Board Exhibit B, you're going to enter the objector's petition and its components. Board Exhibit C will be all the service documents, the call, the certified mail receipts, the sheriff's, are we still required to do sheriff's?
I'll talk about that.
Yeah, okay. And then any waiver of service documents. And then D was always the appearance forms and the non-disclosure forms. So a good way to get the hearing started, as you know, is just to ask the parties, ask the objector, what is this about? Give us a brief description of the issues presented, and please make certain that on the first day, because it's case management, that we don't hear the entire case at that very moment. We don't want to hear everything about the case. We just want a brief summary of what we're looking at, and you will have known that because you will have looked at the objector's petition anyway. But we just want a brief description of the issues that are being presented so that we know, you know where you're going and what has to be assigned and so on and so forth. You want to ask the parties if either of the parties wish to file any preliminary motions, and if so, ask whether any of the issues are dispositive, because if there's a dispositive issue in there, that's always a good thing to know and a good thing to for them to be able to put on the record. If there are motions to be filed, then I would say, I don't know, maybe, I think everybody would probably agree with me, it's usually like 80% of the cases, somebody will file a preliminary motion. If there are motions to be filed, then the filing dates in the rules of procedure have to be followed. I presume they're gonna be the same as in the past, but we don't like to presume. If the objector's petition contains allegations that regarding a records exam, then you're gonna fill out a records exam form and give it to the clerk for further processing. If for whatever reason you are online or doing this remotely, eventually when you fill out the form, you can do it.
These will all be in person.
Right, the first day will,
Yeah.
But if it comes subsequent to anything, then it's possible that you would be just, uploading it to the system that we're gonna be using. This is really important. Once you've had this first hearing date, and for every hearing date thereafter, you have to schedule a new date until the case is done. So, because what we don't want is just cases floating out there with nobody knowing when they have to return and what the deadlines are and when the next hearing is gonna be. So even if it's for status and even if it's on Microsoft Teams, just a status call, always schedule the next date, because we don't want cases to just be floating. So once the hearing is done, as you may or may not know, you then have to submit a written hearing officer's report and recommendation. And the goal is to get it, the rule, let's call it a rule for now. The rule is to get it to Jim and to Holly within 48 hours of the last day of the hearing. So that's hard to do, because if you have a very complicated records exam and then a Rule 8 hearing, sometimes that's really hard. So I have some suggestions for that in just a second. But it's really important that we keep these things moving. The dates are, as you know, unrelenting and unforgiving to get the ballot certified and so on and so forth. At the conclusion of the hearing, you have two choices. You can either render your recommended decision on the record, or you could take it under advisement and then submit your recommendation to the parties and to Jim and Holly at the same time. And then that starts another clock running. So if you know what you want to say, or you generally have the decision that you want to render, you can put it on the record. If you don't know and you need to take it under advisement, you can do that as well. This is something that Jim and I both wanted to stress. Every issue has to be addressed in the report and the recommendation. If you leave something unsaid or undone or undecided, it creates the room that it can be kicked back to us and kicked back to the board or kicked back to you, and it just really delays things. So you want to make sure that every allegation that the objector has submitted evidence on is addressed. Everything in every motion is addressed, so that there's no room to have to go back and forth from the board and back to you and so on and so forth. And particularly, we don't want it to go to the circuit court if it's appealed and then come back down. That creates, creates a really bad scheduling thing. So there's a couple of terms that I know all of you know, but again, for those of you who might be new, there's a couple of terms. So the first term we want to talk about, of course, is the records examination. The records examination, first of all, is going to be taking place at the Cicero, what are we calling it now? Not the warehouse.
The Elections Operations Center.
They will be at the Elections Operations Center, and they have, what did you say, 50 stations?
Right.
So they're really, and they're very, very efficient, and it's a much better process than it's ever been in the past. I think we did this last time, and it worked out great. But so the records exam, as you know, is the process by which the signatures on the nominating papers are checked by the clerks of the board, and with watchers from both the objector side and the candidate side present. And then the rules governing the records examination are set forth in the board's rules of procedure. Just one really quick thing, as you know, if somebody chooses not to be there for either side, and somebody doesn't raise, their own objection to a finding or a call, it's deemed waived. So people have to be present in order to make any kind of objections, to be able to submit further evidence to any finding of the clerks on the signature and the records examination. We already talked about what a appendix recapitulation sheet is. That is the attachment to the objector's petition that sets forth the sheets, the lines, and the basis for the objectionable signatures. It looks like everybody has their own form. It sort of looks like a graph with X's or checks, and everybody has their own wording, but essentially it's how the people that are doing the records examination know which signatures and lines to check. What we know is that you can't have just the ball delegation, well, the signatures are, there's a number of signatures on the objector's petition that are invalid. That lacks the specificity necessary for anybody to do any kind of records exam. So the objector has had to attach something to the objector's petition so that we know which sheets, which lines, which signatures are being objected to. We've all heard this, or some of us may have, and some of us will, hear the term shotgun or shotgunned objections. And as you know, what a shotgun objection is an objection that is where there's an allegation that there's no basis in fact for the objections that have been brought in. Usually you hear the term in terms of a motion to strike. If someone has filed an objector's petition where it appears there was no inquiry made whatsoever and just signatures were just randomly objected to, a candidate can bring a motion alleging that the objector's petition was brought in bad faith and that it should be stricken. And oftentimes what happens there is that sometimes we do like a random sampling, and that's oftentimes the best way to figure out if an objection has been brought, in bad faith without any inquiry. And if the finding is that it has been, obviously then the whole objector's petition is stricken. Then we have a Rule 8 motion. So after the records exam is completed, there's a period of time pursuant to the rules of procedure where either party can file what's called a Rule 8 motion. And it's called a Rule 8 motion because the rule setting out the process is in Rule 8 of the rules of procedure, unless you're changing it,
Nope.
which really messes people up. But anyway, so that's a motion that is filed at the conclusion of the records exam, which is essentially a request for a further hearing on the results of the records exam. And that is another pleading that has to contain specificity as to what the party bringing the Rule 8 motion wants you to be hearing. It can't be a general statement saying there were many errors at the records exam and we'd like to do a further hearing. That's not a sufficient Rule 8 motion. It has to contain with specificity what you are being asked to reconsider as a result of at the end of the records exam. Oftentimes, you will have somebody who files a Rule 8 motion and then brings no evidence. And they say to you, take a look at it. And the answer is no, you don't just look at it. They have to bring further evidence. So if the allegation is that the signature is not valid and that was sustained in the records examination, you're not there to overrule the findings, you're there to consider further evidence. So it's not another chance for either party to have the signature reevaluated. It's another chance for either party to submit further evidence. Lynn?
What about an expert handwriting analysis? For some reason I thought that there was an issue the last time that they weren't doing an expert evaluation, or they were, or when it came in. I just wanted to straighten that out.
A party, as Barb said, a party can bring additional evidence that may be in the form of saying, I have a forensic document examiner, handwriting expert, who has reviewed these and they believe this signature is genuine. If it was found to be not genuine, or vice versa. They can bring in an expert witness. They have to be qualified like any other expert witness, and then you could consider that additional evidence. But there's in our process, the records exam takes place with clerks of the board conducting it. They make rulings. Whatever that ruling is presumptively correct, and it's not a de novo hearing. As Barb said, they can't come back on a Rule 8 and say, you know what, we think the clerk out at the Elections Operations Center didn't get this one right. We want you, Mr. or Ms. Hearing Officer, to take another look at the signature. That is not what this hearing is about. It's not a de novo hearing. They have to have other evidence, an affidavit from a voter, bringing a voter live who said that I really did sign that petition, a forensic document examiner that qualified as an expert witness. So if all they're doing is say, we don't agree and we want you to take a second look at it, that's not a rule that it is for.
Now, there is one, it's not an exception, but there is really one thing that doesn't require essentially more evidence. It's just where it is very clear that either the wrong line was reviewed and a finding was made on the wrong line, or to the wrong signature, or the wrong category. You know, if you have an objector's petition that alleged that the person was out of district, and you have some other finding that is not consistent with what the objector's petition says, then, you know, that's a, okay, we're good. I'm just having trouble with this, and sorry about the bad scrolling. I don't know. Hopefully you can see it, sort of. I don't know. But there's sometimes where somebody can bring something to you and say, look, they just really made a mistake. It's not a subjective, decision from a clerk. It's just a mistake was made. And those are things that, you can consider.
Yeah, like Barb said, if the objector's petition, which can't be amended, as you know, objected that the person was out of district, and the records exam results say signature not genuine is sustained. If that allegation was made, they can bring that to you. You can look at it, cross-reference it with the objection, and say, yeah, a clerk just hit the wrong column when they were doing this, so I'm going to overrule that. But that's not going to be a lot of times.
Right. And as Jim said, what we're really looking for in a Rule 8 hearing is evidence of some kind with respect to the validity. It's usually the validity of signatures. Sometimes there's additional evidence regarding the registration. There can be additional records regarding the person's registration, but most of the time it's regarding the validity of signatures, which really does take a handwriting expert, testimony, individual testimony, or an affidavit. And then there is the Rule 20 motion. Is it still going to be 20, Jim?
Yes.
Okay, good. It's a motion a party files if they want to have, at the conclusion of a case in front of a hearing officer, if they want to have additional opportunities to present arguments in front of the Electoral Board. This goes back to my point about please make sure that your recommendations are complete. Because at this point in time, this is one of the points in time where the hearing can get kicked back to you to finish up. And again, it just slows down the process. And then even after the fact, if it gets appealed, it can be kicked back. So again, it's really important that your reports are completed. One of the things that I wanted to mention to you, these are just what are intended to be helpful tips, is that you need to count. And I know it sort of sounds like, just of course we need to count it with with our signatures, you know, and determine where you end up. But one of the things that I sometimes do is I go through the reports, you know, with Jim or with the other boards, and then, you know, help to kind of like do a summary. And I've been involved in cases where the decision was wrong because the counting was wrong. So when you're doing a Rule 8 hearing, find a system that works for you. What works for me is that I write down, as each one is presented, and any evidence is presented on a signature, I write down the name, the sheet and the line, and then I have a very simple way of doing it. I put a plus sign, a zero, or a minus sign, meaning, a minus sign means that the candidate just lost the signature. A plus sign means that they just gained one, and if it's nothing, it's nothing. I usually put an NC for no change. However you do it, there's no wrong or right way to do it, so long as at the end of the day you actually have the count correct. Because if you don't, it could change the results of it could change the decision. And as I said, I've been involved with some cases where I've gone through the record on some cases where a determination was made, but then the count was off, or a determination wasn't clear from the record, so you couldn't go back and say, what did the hearing officer do on this particular signature? It was like there was no decision, so then there was nothing included in the count, and ultimately the decision was wrong. So when you're dealing with a Rule 8 hearing, just please find a way to keep track of it. It's hard to keep track of because sometimes they move fast. You know, whatever kind of way you keep track of it is fine, so long as you do keep track of it. And at the end of the day, you have to be able to say, after the Rule 8 hearing, these are the number of valid signatures that are contained in the candidate's nominating papers, so that your decision can say, and this is either above or below the minimum required, and the candidate is either on the ballot or off the ballot. And oftentimes it comes down to like one or two signatures where it's not really clear, and if it's not clear what you did, and you can't go back to look at the transcript, it kind of creates a problem. So I think I've made that point clear enough, hopefully, but just I wanted to remind you of that. So I presume are there any questions so far? Because Jim's going to take it from here. And thank you for sorry about the bad scrolling situation. So hopefully you were able to use the handout.
That's why we went to law school,
right? I did, yeah.
Not
it's a technical,
lawyer.
right? It was technical, right?
Thank you, Barb.
Sure.
I really appreciate Barb taking the time. I'm not exaggerating when I tell you she is the most respected hearing officer in the state. Every board that she works for wants her full time, and I'm just glad that we got her at least part time.
That's very nice.
So let's talk about a few things. We are going to conduct these hearings in kind of a hybrid manner. Those of you who worked through the pandemic, for our municipal cycle, we did all the hearings remotely because that was kind of the height of COVID. This time around, we are going to have some of the hearings in person, and we will be giving you as the hearing officer an option to conduct other hearings remotely if you wish. We use Microsoft Teams, and Microsoft Teams is similar to Zoom. It's a different system. Our IT people think it's a more secure system than Zoom, and that's why we use it. Those will generally be hearings that you will have discretion on scheduling, but there's parameters for your discretion. So first of all, we plan on convening the Electoral Board on the 28th of March, which is a Monday. The board will convene in the morning. That will be sometimes referred to as the cattle call, where the board adopts rules, takes care of administrative things, and makes the case assignments on the record to each of you as hearing officers. You will know in advance which cases are going to be assigned to you, and ideally we will begin the hearing officer hearings later in the day on the 28th. Because I'm not sure what the volume of cases is going to be right now, it could be initial hearings may carry over beyond the 28th. So you may have some initial hearings on the 28th. I'm also working with the state and the city, so as much as possible, we don't conflict in terms of scheduling hearing officers at the same time. So it's certainly possible that after the 28th, you might have some additional initial hearings on the 29th or maybe the 30th. So again, you will be contacted in advance. You'll be given a draft schedule and docket of when you're going to be doing hearings in what cases. As Barb mentioned, once you look at that docket, you need to let me know if you think there's any conflicts. The offices that are going to be contested at this election are going to include water reclamation commissioners, all countywide offices, so county board president, assessor, clerk, the treasurer as well. The state's attorney is not on the ballot this time around, nor is the clerk of the circuit court. All 17 county commissioner districts will be contested at this election. There are new district boundaries, and people will be running. Some people will be new, some people will be incumbents running, but all of those will be contested. The Cook County Board of Review Commissioners, there are 3 districts within Cook County. All of those commissioners will be on the ballot this time around. Additionally, we will have judicial offices, countywide judicial offices, as well as sub-circuit judicial offices. This cycle also, the township committee persons for political parties are also up for election. So all 30 townships will have people running for township commissioners within those districts. So there's going to be a wide variety of offices and a wide variety of signature requirements and other requirements. For instance, as Barb mentioned, the people running for political office, which is say a Democratic or Republican township committee person, they're not required to have a statement of economic interest receipt because that is not a government office, so they're not required to file a statement of economic interest. So they don't file the statement, nor do they have a receipt. So if you get an objection to so-and-so's running for committee person in Worth Township and they didn't file their economic interest receipt, that's not going to be a valid objection because they're not required to do it. All government offices, you are required to file a statement of economic interest and file a receipt as part of your nomination papers. Just as an aside, the statement of economic interest has been revised by the legislature, so there will be a different form. We've revised our form. Some of you may remember, as far as people who file their statements with the Cook County Clerk, the old receipt was simply a photocopy of the first page of the statement itself. That has changed. The statement is a separate document now, and the receipt will be a separate document that will be time-stamped and will be labeled receipt. So don't look for the first page of any statement of economic interest. You may find some people who file their statement of economic interest as part of their nomination papers. That's a problem if it's been objected to, because you are supposed to make a separate filing of that document, and then the receipt for that filing is what you file as part of your nomination papers. So be aware of that. We will have, as part of our Microsoft Teams, the hearing officers library. Most of you have done this before. We've created a library, and every cycle we update it, often with input from you, where you say, hey, it would be handy to have this document that we could refer to as an example. So I will be creating a hearing officers library again. Generally, we'll have in there copies of our rules. I generally make available the ICL on election law, and particularly for your purposes, the first chapter, which has been authored for decades by Tom Giaconetti, and as detailed as you'll ever find, because Tom's that kind of a guy. That's the one on ballot access, and almost all the topics that you're going to see as a hearing officer will be covered in that chapter. Additionally, although the county does not have an index, it was not a practice prior to this for those prior decisions to be indexed. The city of Chicago has a very thorough one, and I'm going to include a copy of theirs as persuasive authority. They deal with basically the same issues that we do as hearing officers at the county. So you will find that a useful resource to look at electoral board decisions that relate to some of the issues you're going to be facing with the objections here. I'll also have a form recommendation. We will also have, I think everybody's found this very useful, we instituted a hearing officer's checklist. So for that initial hearing, you're gonna have a checklist like Barb talked about that will take you through start to finish what you need to do at each initial hearing to make sure you cover all the bases, capture all the information, capture all the forms that need to go into the record. And it's literally a checklist, so you can go down and put an X next to each thing as you do it. The first day of hearings are going to be mandatory in person. They will not be allowed to be done on Microsoft Teams. The reason for that is the first day we collect appearances from the parties, other documents, and it's important to do that in person so we know everything that we need to proceed gets into that file. Appearances from the attorneys, all these documents will be done in person. So the initial hearings will be done in person, and those will take place here on the 22nd floor. We no longer have the room in the Pedway. The lottery's down there now, although it's probably a form of lottery when we were doing hearings in there. But we will be conducting all our hearings on this floor in various rooms. So again, we're in hearing room D today. We'll be designating different hearing rooms on this floor for your hearings, and you'll know that in advance from the docket. Just be aware that the general rule is we give people a 15-minute grace period to show up at the initial hearing. The other thing is, as you're probably aware, there's a small core of attorneys who do this. And very often they may be required to be at several different hearings during the same time frame. So it's not uncommon for them to send word or to tell you as a hearing officer, Mr. Rosas, I got something, with Mr. Brennan, I gotta run over there, but I'll be back. So we gotta give some leeway to these attorneys. They usually have very heavy dockets, and particularly on the first day, they're trying to appear at multiple hearings close to or at the same time. So if somebody does that, show them some professional courtesy. You can defer that matter. If somebody shows up for the next hearing, you can take care of that hearing while you're waiting if the attorney is still absent. We generally set these at half-hour intervals. So again, we give people a 15-minute waiting period. If nobody shows up, we begin. If somebody shows up early and you have extra time from the hearing that just completed, if all the parties are there, you're free to go ahead and begin that hearing and take care of the administrative stuff. So it's going to require you to be somewhat flexible, particularly on the first day. After the first day, you have a lot more control over the timing of your docket, and you should be able to set these hearings in a way that you're not going to be worried about them bumping up against each other. I anticipate we're going to have a lot of records exam cases this cycle. And the reason being is the legislature, as you know, pushed the primary back to March. Normally we'd be in the middle of everything right now.
Primary back to June.
Into June, I'm sorry, yeah. The filings in March, primaries in June. So we will be starting our hearings then the end of March and into April. So I am advising everybody, you may have children, you may have school vacations. If that is something that you are planning a trip to Florida or something, it's probably something that's going to interfere with your ability to serve here. Because once we start in March, we're going to go through and finish these hearings as efficiently and quickly as possible. So my rule is don't schedule a lot of other things for April, because we're going to be pretty busy here. The records exams are all conducted out at our Elections Operations Center, which is out in Cicero. It's a newer facility. It works out very well. We can distance there, and you are not required to be at the records exams as hearing officers. You schedule them. If there are issues that arise, you may get a call from the parties that you can deal with if you think over the phone. But that's pretty routine, and then the results of those records exams then are reported to you as a hearing officer. That's when the Rule 8 hearings and stuff may start. We're trying to do as much as we can to make sure that we can get these hearings moving the very first day. Unfortunately, the statute still requires technically that a party be served by the sheriff and certified mail with a copy of the objection and the notice of the board hearing. What we've started the last couple of cycles is we're asking when people file next week, and when people file their objections the week between the 14th and the 21st, we have waiver forms, and we're asking the parties to waive personal service and give us an email, and we will email them the objections, the call of the board, and the documents they would need to appear at the first hearing. Anybody who's an attorney appreciates this, because if you are objected to, you want to get your hands on that objection as quickly as possible, and your attorney does, so that they can review it and to find out what the nature of the objections. Is it a signature objection? Are they alleging residency issues? Whatever. So we've had pretty good luck with people signing up for the waivers, but there are a certain number of people who just don't want to cooperate. We have to go through the formal service. So one of the things that will be on your checklist will be confirming service of the documents on the parties that first day. And that can be as simple as the parties having appeared, you know they're there, and you just say, did you get a copy of the objection? Were you served with a copy of the board rules? All the things that Barb identified in her presentation. And again, your hearing officer checklist will have these items on it, so you just walk through that and check each box as you confirm with the parties. If there's not proof of service on a party, that means that we did place it with the sheriff for service, and the sheriff either has not been able to serve them yet, or we've not gotten a return of service from the sheriff. If that's the case, you would have to continue it for a short date, and at that point, hopefully then the sheriff will have served the party that needs to be served personally. They will either have appeared or will have a proof of service in the record. If there's a proof of service in the record and the party doesn't appear, you give them their 15 minutes. You do have the ability to default the party where we've confirmed there's been service on it. We have to be fair to people, but we also have to be very efficient, because all of the hearings need to be completed as quickly as possible so that we know who's on the ballot and who's off the ballot. Because mail ballot voting will be starting in May. They'll be able to request mail ballots as early as March 30th. So we got to move, and I emphasize this again if there's any new people in the room. These have to be done. This isn't, yeah, I'd like 28 days to answer, and you'll have 28. No. The rule generally is if there's a preliminary motion, 5 o'clock the day following the hearing. A response is 5 o'clock the day following that. If a reply is going to be filed, 5 o'clock the day after that. And then you're setting your hearing a day or two after that to deal with any motions. So I have to emphasize how quickly all this has to be done. As far as the hearings go, the hybrid hearing, you will have discretion if it's a matter of scheduling or something that doesn't involve substantive activity on your part, to schedule it as a Microsoft Teams remote hearing. So if it's simply a status hearing to make sure certain things were done that you ordered at the prior hearing, if it's a scheduling thing where the records examiners come back and somebody's filed a Rule 8, okay, so when do we want to do the Rule 8 hearing? That's okay to schedule as a remote hearing. But we are going to require any evidentiary hearing be conducted in person. Obviously, if it's an evidentiary hearing, there may be witness credibility that you as a hearing officer have to evaluate, and you need to have the person in that room. So routine scheduling type things, I'm leaving it to your good judgment about whether you want to do those in person or remotely. Sometimes you may find that you want to do it in person just because you're more comfortable with that, or there may be some peripheral things that you can deal with by having everybody in the same room at the same time. But we do want to give you some options. Lynn?
Are you going to have court reporters, and will they be there for the, if you've got a remote hearing that's just basically setting dates or something?
Yes.
Do you want to get involved with the court reporters?
There will be court reporters at every hearing. If we are doing a remote hearing, the court reporter will be appearing remotely as well. And everything's going to be reported. We always have court reporters at every hearing, and you should not start a hearing without a court reporter. So there'll be a transcript of everything.
Do you want in each week, for each hearing date that said, do you want the hearing officers to tell you if it's gonna be in person or if it's gonna be?
Yeah, we will need to know that.
Yeah.
If it's a Microsoft Teams, we have to have an employee, then one of our clerk's employees set up that Microsoft Teams meeting. So if you are planning on doing a Microsoft Teams hearing as opposed to a hearing in person, you need to let us know ASAP, Holly, and then we will make sure that we schedule an employee who will facilitate the Microsoft Teams. They will generally convene the meeting, he will sign in as the hearing officer, the parties will sign in, the court reporter will sign in, and then conduct the hearing. So we want to give you some leeway, but you know, when in doubt, hold the hearing in person is kind of what I'm trying to say here. Frank?
If you're doing a remote hearing, is that gonna be able to be viewed by the public, or is that gonna just be between the parties?
We would have to make the availability to the public on the hearing, so we would have to make Zoom information available. Generally it's very rare that members of the public would be interested in attending a scheduling hearing. You know, more often than not, it would be an evidentiary hearing. And Rule 8s are evidentiary hearings. So if somebody files a Rule 8 motion to contest the results of a records exam, that needs to be conducted in person. And just to review, it's not a de novo hearing. It's not where, you know, Mr. or Ms. Hearing Officer, they said this really wasn't the person's signature, but look at that big swirl on the G. That's the same as the one on the registration record. They have to have new and independent evidence of some kind presented at a Rule 8. Otherwise, if all they say is we want you to look at it again, your ruling would have to be no change from the result of the record exam and move on. Barb talked about a system, pluses and minuses, or I always did it that way. You know, if you start a hearing where a candidate is, say, 5 below the minimum, you're going to, you know, a plus would mean they're 4 below the minimum. A minus would mean they're 6 below the minimum. So whatever system you want to get, but then check your math very carefully. I anticipate a lot of records exams because anecdotally, I'm just hearing how tough candidates are having a time of getting signatures. And it's not surprising. They could start getting signatures till mid-January. The weather's not cooperating. With COVID, it's not where you knock on someone's door and they invite you in to sit at the kitchen table so they can sign all your petition sheets. So I anticipate, you know, my old rule of thumb when I was practicing, I told people get 3 times whatever the minimum is so you're bulletproof on your signatures. I'd be real surprised if a handful of people get 3 times the minimum. So you're going to see a lot of people much closer to the minimum, and you're going to see a lot more than objections, I think, saying we reviewed them and, you know, they only had 300 signatures over the minimum, and we have 600 objections saying they don't have enough good signatures. So I think there'll be a lot of records exams this cycle. We are prepared at the EOC. We'll have 50 workstations out there, so we will be trying to get these records exams done as quickly as possible to get the case back to you as a hearing officer for whatever further proceedings you need to do. The other thing is, Barb mentioned a very important thing. If there are allegations in the petition, what often happens is somewhere along the line, parties will abandon certain allegations. So they might make a residency allegation saying, well, this person isn't a resident of the district they're running in, so they're not eligible to serve. When the results from the records exam come back and say the candidate is up by 400 signatures, they may decide, I'm going to just withdraw my residency objection. I don't want to go any further on that. You still need to note in your recommendation that, you know, paragraph 14 was withdrawn by the objector. So the easiest way to do it is go through all the paragraphs. The initial paragraphs of an objection are generally going to be jurisdictional stuff. But when you get to the meat of it, like paragraph 14, the signature is not genuine as set forth on the recap sheet under heading A. Paragraph 15 is they don't live in the district as set forth in column B on the recap sheet. You can group that and say paragraphs 14 through 20 were signature objections. The results of the records exam showed that the candidate had
400 signatures more than the minimum. But make sure you address all, if paragraph 15 is the residency and they withdrew it, say paragraph 15 was withdrawn, and then move on to paragraph 16. But make sure any substantive allegations are addressed in some fashion. Like I said, the signature one should, if you want to group those and just say the records exam showed as to all the signature objections that the candidate hit 400 more than the minimum, that's fine. But make sure you address them, because either our electoral board will kick it back to you, or they go across the street to the circuit court and they'll kick it back to the electoral board and will eventually get back to you. So just kind of use the paragraphs as a guide and make sure you address each one. And if they withdraw it, it's simply paragraphs 14, 22, 29 were withdrawn. Then if somebody looks at the objection, they see it's been dealt with. Let's see, what else?
Sheriff?
Oh, there may be some cases, and just as a refresher, where people raise constitutional arguments. We are bound as an electoral board to only interpret the election statutes or any statutes that may impose on that. So if there are certain qualifications for an office, for instance, there's been some stuff in the media, you've probably seen it, that there's a new qualification for county sheriffs, that they have to have a certification as a peace officer or police officer. We may or may not get objections on that. If we do, the issue will be, does the person comply with the statutory requirement? There may be peripheral attacks on it. Somebody may say, well, that's not constitutional. You can't compel somebody to have this certification if they want to be a sheriff. That's constitutional arguments pursuant to case law are not justiciable by an electoral board. And as Barb pointed out, you are an extension of the electoral board. Let people make their records, because they do need to raise a constitutional argument at the electoral board level or its waived. Let them make their arguments, not ad nauseum, but if they say, here's my equal protection argument on why this statute is unconstitutional, let them make their argument, note it for the record, but we as an electoral board don't have authority to decide a constitutional issue. Then, if they want to take it across the street, you've got judges in robes who do have that authority, and they can take it from there.
Is that the situation where certain individuals are seeking the office as sheriff, and they're actually corrections officers or something to that effect? And they say that those individuals do not qualify under that statute of being a certified peace officer?
That may be an objection. I haven't seen it. That's what's been in the news, is that there was a new statutory requirement applied to eligibility for sheriffs, although there's a grandfather clause exempting anybody who's currently sitting as a sheriff from meeting that requirement.
So what's our position going to be in a situation like that, where a person is impugned as not being qualified because he is not a peace officer? We're ruling on the statute?
We will have to rely on the statute,
Okay.
the definition of what a peace officer is in the statute, and we'll make a ruling based on the statute. But when they say it violates equal protection because sitting sheriffs are exempt from this requirement, make your equal protection argument, and the Constitution is applied at the Daily Center, not here. So we want to make sure people can make a good record, but it's not within our wheelhouse to make a ruling on an issue. And that's an example. That may or may not occur, but there may be other constitutional arguments made in relation to other offices or qualifications. So just be aware, constitutional arguments are something that we allow people to make a record on so they preserve it, but it's not something we're going to rule on. Frank?
You anticipate a lot of residency issues due to the remaps?
Usually in a redistricting year, there's residency issues. There's a lot of forgiveness, usually not for every office, but for a lot of offices, the rule can be that if there's a new first district, if you lived in any part of an old district that's now in the new first district, you can run in that district. We'll have to take that on a case-by-case basis, because each one of these offices has different schemes as far as who, essentially, even if they don't live within the current boundaries, qualifies to run in that. The good thing is they redistricted judicial subcircuits, but that doesn't take place until 2024. So there'll still be 15 judicial subcircuits this cycle, and the boundaries will be the same they've been since 1992. So, and generally speaking, lawyers being the people running for judge, those are the largest number of cases are usually objections in judicial races. So we're not gonna have to deal with redistricting. In 2024 we will, but we'll deal with that when we get there. Other questions? So we will be convening the board the 28th. We will send you out an email next week sometime with access to the hearing officer's library if you want to get a head start of looking at some of the documents in there. If you have any suggestions or any questions, I'm going to give you my card after we finish up here. And actually Barb has my contact information and Holly's on the PowerPoint, and you will have a hard copy of that. But I'll give you my card too, so you can call me. Otherwise, then expect sometime next week I'll get you linked to the library, and you can start looking at forms. And if you want to look at the ICL or any of the others, Barb's PowerPoint will be on there as well. We've asked Frank Herrera from our communications department has videotaped this session today. So if you want to go back and review something that you heard today, that will be accessible through the hearing officer's library as well. So we want to give you guys all the tools you need, because you're going to be doing a lot of things in a very short leash, and the more you can prepare now and get ready, the better. But again, if you have questions or there's just something that doesn't make sense to you or whatever, give me a call.
So we're going to be getting the pleading the objections after the 21st of March, right?
Right. And we will give you a docket probably towards the end of that week.
Hopefully a lot that time before the 28th.
Well, the problem is this: most people wait till the 21st, which is the last day to file the objections, and we got to process them.
Okay.
So I will hopefully have a docket by the end of that week that I can send everybody, so you'll know in advance what days we've scheduled you.
Okay.
And then if you, again, take a look at the cases, and if you perceive any conflicts or you want to discuss whether you have a conflict on something, let me know. Again, I will say this: you've seen the same cast of characters of lawyers who handle these cases. It's not a conflict just because, well, I had a case with, Ms. Jones last cycle, so I ruled in her favor on that case. Do I have a conflict now? The answer is no. Okay. Anything with the lawyers, now if it's your law partner, maybe we have an issue, but generally speaking, things like that are not considered to be a conflict. But you may have a family member who's running for office, or some situation where you would not feel comfortable handling that case for some reason. If that's the case, you can let me know. And as Barb said, I want to deal with that up front. If that is something that I need to reschedule, I want to reschedule it before the 28th, so that our docket, is clean, and when people appear on that day, then we're ready to go. Chris?
What are the dates and the hours that you're going during which we can hold a hearing?
We'll be holding hearings generally during normal business hours, which would be 9 to 5, particularly where we need to have our staff there to work as clerks. They have set hours that they work. If there's a rare occasion for some reason that we need to hold a hearing on a weekend, you could discuss it with me. I'm not going to be really receptive unless it's like the last weekend in April or something like that. But then I'll have a real problem about why did this take to the last weekend in April. So generally speaking, it'll be Monday through Friday, 9 to 5. Frank?
Last question. What are we doing in regards to, are we requiring masks on the first day, no masks, your choice?
The policy of the building and our office, based on the recent developments, is that masks are optional.
Okay.
If that changes, we will follow whatever the policy is at the time the hearings are taking place. But right now, the policy in this building is that masks are optional. That means that you are free to wear a mask, employees are free to wear a mask, parties are free to wear a mask. The only issues were, you know, obviously, it shouldn't be an issue is if you're doing a Teams meeting, you're not gonna worry about it there. And occasionally, a court reporter, even on a live hearing, may say, could that person take off their mask? I can't hear what they're saying. So you would have to try to accommodate that, obviously, so we have a good record. These will be court reported, but keep in mind, as you know, the court reporters are gonna be handling lots of hearings, so we're not gonna have, you know, like one-day turnarounds on transcripts or anything. If you have a hearing where you think it's particularly crucial, before you can do a recommendation, that you get a transcript, or maybe a transcript of a particular witness or something like that, let me know. You know, we can get the court reporters hopefully to make some accommodations. But again, they're gonna be doing hundreds of hearings this cycle, and they're not gonna be turning around transcripts on a dime. So take good notes. But again, if it's important to make a final recommendation, you really need to read, say, testimony or something, let me know, and if we can expedite it, we will. There may be rare occasions also, if there's a Rule 20 hearing, which is where a party takes exception to the recommendation that you make, and they have a chance to argue before the Electoral Board. On occasion, some of our Electoral Board members will ask that the hearing officer be present at that hearing so they could ask questions about the procedure. If that's the case, I'll let you know, and if you can be there, then you would obviously appear and be available to the Electoral Board to answer any questions that the members might have. Anything else?